and you shall be heard. God said the Commonwealth of Massachusetts, court is open. Please be seated.
Thank you kindly, Gio. Good morning. Welcome to the Massachusetts Appeals Court. My name is Judge Desmond, and it is my honor and your good fortune that Judge Hand to my right and Judge Grant to my left will be joining us for your panel today. We'll be hearing all 6 cases. I see many familiar faces, so I know that you've argued here before and are familiar with the process, so I won't go over too much of that. We'll probably take a break after our 3rd case for about 15 minutes, and then we'll resume. Our first case is 2023P0862, Department of Families and Others versus Mother. Attorney Butler.
Good morning, Your Honor.
Good morning.
Good morning, Justice Desmond, Justice Hand, and Justice Grant. Deborah Sirotkin Butler on behalf of Appellant Mother. This case reminds me of 2 of my prior cases, adoption of Linus and adoption of Betsy, in different ways. This mother, foreign-born and doing her best to raise 3 children, is left without any of them. And regrets, as the record shows, moving to housing in Spencer. In 2019, all seemed to be going well. The goal was reunification. Visitation was occurring in the community. She had completed a parenting class. She had completed what was on her plan from the department, now much more properly called an action plan. They were once called service plans, but really they were task lists. She had done it all, and she had another baby, and to her shock, that child was removed from her in the hospital, and...
Why do you think that was?
Pardon me?
Why do you think that was?
Because she is a woman who spoke her mind. When a child was bullied, she confronted the school, perhaps injudiciously. Certainly in Spencer, she was a unique person.
When you say she was a unique person, what does that mean?
She was the only person of her background.
Her background being from Jamaica or being
Being
black?
from Jamaica.
What are you saying?
All of that. Right on point, Your Honor. Thank you.
Say it. You say it.
She felt that she was treated differently, as less than, and that everyone was watching her all the time, and that her child, when her child was bullied, there was no recourse, and the school treated that as disturbing the peace.
Well, you say that everybody was watching her all the time. Didn't she make some complaints that they had bugged her apartment and they were following her? Is that what you mean when you say they were watching her all the time?
She felt that whenever she spoke up or disagreed with people in any degree, that she was treated badly, poorly, differently than the others around her. She felt it was racism, yes, and that's how she called it out. And that's reflected in more than one report and more than one document in the record. And the school filed a 51A because she was loud and noisy, and they didn't like the language she used, and there's nothing really in the record to tell me exactly what she said or exactly what they said, but that they called it disturbing the peace, that the record is clear about.
Did she get arrested for some of those instances?
She was never convicted of
Get
anything.
arrested for some of those instances?
I think so. I think so. I don't practice criminal law. I did look at her query, and I did check mass courts, and what I found were no convictions, but a lot of noise. And when I say a lot of noise, the words used about her were words like loud, belligerent, angry,
Aggressive?
aggressive, verbally aggressive. Is there a record of her assaulting anybody, any conviction for anything? No.
When she confronted the school personnel, did she aggressively approach the school personnel?
It's unclear. There's no conviction, and I wasn't there. Did they view her as aggressive? Absolutely. Did they use that word in their paperwork? Absolutely. Do I know what actually happened? No, I don't.
Well, speaking of I wasn't there, what do we do with the fact that Judge Bolivar saw this mother testify, and he found at page 54 of the record, well, I guess it's finding 36, mother was unable to complete her own testimony due to her behaviors and mental health inhibiting her ability to testify appropriately. So I understand that mother is angry, but the judge had the opportunity to observe her and to decide if this was justified anger that would not inhibit or interfere with our lodestar, which is the best interests of the child.
What I know is my client said, I'm not going to keep answering the same question. I'm not going to let these people laugh at me. And she simply stopped answering. The citation to that is in my brief. That was what was on the record. And when I looked at the transcript, I saw a number of places where I would have said, asked and answered, harassing the witness.
Share one with me.
Your Honor, I didn't carry in the whole transcript, but what I did do in my brief is cite to where that happened in the transcript. So,
But it wasn't just at trial. Am I understanding correctly that, or it wasn't just with respect to the questioning at trial, but the mother was asked at trial whether she had completed certain tasks on her action plan, and she indicated that she didn't and she wouldn't. Isn't that correct?
what mother had said, to my understanding, is that she had already done a parenting class.
Which she did not confirm and would not, she didn't provide releases to allow the department to confirm all of the services that she indicated she had taken.
The department had it in her record. But see, this was 2019 when she completed these things, and they wanted her to do it again, and she said no. So that's true. She said, no, I've already done that. I'm not going to do it again. And she didn't understand why they wanted her to do it again. And it is also true that mother herself had been in foster care at the age of 7 and had had very traumatic experiences, which I don't have in detail, and began her case with real fear of DCF. What the record shows is prior to Soraya's removal, she had enrolled her son in baseball. She had advocated for him to have an individual education plan.
Was that MD or which son?
Pardon me?
Which child are you referring to?
The older boy who was in her custody, not the two sons who aged out of
And was he the son who she hit in the head with a perfume bottle?
She denies hitting him in the head with the perfume bottle. She does admit that she and he sometimes had angry interactions, and that she threw a 1-inch bottle at him, which to me she seemed to regret. But no, she didn't walk up to him and strike him with it. She didn't apparently hit him with it. It may have been thrown in his direction, and there may have been a single incident of that, but there is not any repeat of that.
And then I believe she testified that he was a liar in no uncertain terms. Is that right?
She said that he was untruthful at times, yes. I wish none of my clients were untruthful. I can't say, however, that that's true. And I myself have no way of knowing whether that child was always truthful or not. But she certainly felt that at times he was not, and said so, and it's in the record that she did say that.
Was she complying with her mental health treatment?
Pardon me?
Was she complying with her mental health treatment?
I believe she had been complying and had a good relationship with a therapist who left the practice, and then she had difficulty establishing with someone else. I think there is a shortage of mental health treatment in the state, and I do not know as of today whether she is in treatment or would be considered to need treatment.
Well, was she compliant at the time of trial?
At the time of trial, I believe she was between therapists, and I do not know if the reason for that was the therapist who left the practice and the shortage, or whether she had given up with finding that helpful.
Was it not the case that the department, at the mother's request, provided or put her in touch with a therapist, I think, who was Jamaican, or a therapist of color, and then mother failed to undertake the intake with that person?
I know there were a number of difficulties with therapy being up and running. I don't know that she deliberately avoided an appointment, but I do know there were difficulties.
Could I ask a question on a different topic? With respect to the conditional order form, was there a challenge raised to the conditional order form below?
There were actually two single justice hearings about it. At one point, this court ordered the Worcester Court to comply with 29C and to do things that it hadn't done. And also, that form was used prior to care and protection of Walt and prior to care and protection of Rashida. I don't know if it's still in use. I'm not a practitioner at the trial level in Worcester.
Maybe you've answered this question and I just didn't understand it, but was there an objection raised on due process grounds to the conditional
Yes.
form in the trial record? Or in the appellate record? Show me where that is.
What I am aware of is that a single justice appeal was filed. In terms of whether there is an objection on the record in the transcript, I think at the time of the conditional custody order, that attorney made a decision to go the single justice route, and then that attorney became no longer mother's attorney, and the attorney at the time of trial was a different attorney than the attorney at the time of the conditional custody order. So I'm not sure how well coordinated that was.
Could I ask another preservation question? With respect to your client's argument about racial bias, am I understanding correctly that the basis of that argument is the mother's view that across the board she was treated differently because she was black or because she was Jamaican or both? Or is there a separate racial bias argument that you're making?
Actually, there's a misogyny argument parallel to the racism argument, which cites back to adoption of Betsy when that appellant was called belligerent, and even though it was a reported decision, no judge of the appeals court signed it, perhaps because she was so belligerent and had a lengthy history of pro se appeals in addition
rescript?
to that case.
Is that a
Yes,
rescript?
it's a reported rescript opinion, adoption of Betsy, and the appellant in that case, as I found from my research, also had done a number of appellate
Let
cases.
me just, I'm sorry to interrupt you on this, but I see your time is short. But with respect to the question in this case, was there a separate racism claim raised at some point along the way at trial, or is it your argument?
Not in a legal way. Mother, when she was on the stand, complained about racism. None of the attorneys she had filed a complaint about it. What I found is that the language in the Hartsing case from Ohio that I cited to, that the language used about mother seemed to hark back to an earlier era where it's the language of a shrew, of a virago, of a belligerent, angry woman.
Is there any
that-
case law on common scold in this context in Massachusetts?
The closest case is Betsy, in my opinion. And from Betsy, I found the cases in other jurisdictions cited.
And those are in your brief?
They are.
I think we'll have to leave it there. Thank you very much.
Thank you, sir. And we will hope that the day of the common scold has ended with this fine panel.
Attorney Braithwaite? I believe you'll be splitting your time, is that correct?
That's correct. I'll be doing 7 minutes, followed by 5, and then 3.
Okay. Perhaps you can pick up where Attorney Sorkin Butland left off with respect to, was mom treated in a disparate way because of her Jamaican origin or her color?
The record does not reflect that she was. I'll just introduce myself, members of the panel. May it please the court. I'm Kristen Braithwaite, Assistant General Counsel for the Department of Children and Families. And yes, mother makes the argument repeatedly in her brief that she is treated differently because she's black, but she points to no evidence beyond her feelings. And I'm happy to talk about some of the examples she uses. I would point the court to Bulwer versus Mount Auburn Hospital, as well as Dorman versus Norton Co. Mother does not meet the threshold for showing bias. She points to no pretext. She points to no disparate outcomes. Some of the claims that she makes, she suggests she was found to have violated the terms of her conditional custody violation because of racism. The record makes quite clear that there were terms of the conditional custody that she violated. She argues that she was aggressively cross-examined because as a black woman she was being picked on, ridiculed, and scorned, but she doesn't point to a single question that she was asked that was improper or in support of this proposition. I'd also like to point out that she challenges none of the court's findings. So she had the opportunity to indicate that any of those findings were impacted by mother's perceived by the racism that mother perceived in the case, and she didn't do that. I'm happy to talk about a couple more instances, or I'm happy to move on if the court prefers.
It's your time.
Okay. Well, I'm here today asking you to affirm the lower court's decision. The decision reached by the court in this matter was correct. There was abundant evidence that mother was unfit and that it was in the best interest of the children that her rights be terminated. Contrary to my sister's assertion that there was maybe one incidence of violence, the record reflects that in the lead up to the initial removal, mother was repeatedly physically abusive to her oldest son. And while the child wasn't removed, the evidence suggests that in one occasion, a reporter witnessed mother beating the child with her fists. And there was another instance where she was alleged to have abused him as well, also all before the removal. After the children were removed and over the course of the 4 years that this case was open, mother remained verbally abusive to the children and others, and she was never able to prioritize her children. And that was a direct finding of the lower court. Mother failed to prioritize her children. She attended visitation inconsistently. When she did attend, she was often inappropriate, on multiple occasions leaving the oldest child in tears.
May I ask one question on visitation, which is a little removed from your argument, but after the December 1st, 2022 visit, in which, if I recall correctly, the oldest child was left in tears, were there other visits offered to mother between then and the time of trial?
Yes, and I know it's unclear from my sister's brief, mother's visitation was never terminated. The issue is with regards to whether or not there was a willingness to attend. I believe the oldest child only refused to attend one, and it was in the aftermath of that particularly difficult visit. As I know this panel is aware, the middle child, in fact, refused to go for a period of time. But I think it's very important in responding to some of the claims made in mother's brief to note the department did not cease visitation. The department continued, as was its obligation under 110 CMR 7.128, to promote visitation. And I would point the panel here to adoption of Daisy. This was an instance where, while the department is absolutely required to try to encourage visitation, the department is not in a position to force a child to go against her will. And I think it's important to take that a step further and indicate the department didn't just say, you have a slot and leave it at that. The department made repeated efforts to communicate with mother around what mother could do to make it a hospitable environment for the middle child who was refusing. Mother at one point refused to talk to the department. She at another point indicated flat out, if this child doesn't want to visit with me, I don't want to visit with her and I'm done. So
Clear from the record that mom was frustrated with the department. Would you agree with that?
I would agree with that. I think it's important to note she was frustrated with virtually everyone she came into contact with. So I don't think it was just an issue with the department, but I would absolutely agree that she was frustrated with the department.
In one of the instances, she attended or appeared at the school early and was not allowed in. Is that what happened?
That's correct, yes. The department wasn't present when that happened. So that was the school. So that was the oldest child was in a therapeutic boarding school. Mother arrived prior to the child having been dismissed from school, prior to the social worker who would have supervised the visit arriving. So it was not that the department said mother cannot go in. It was that the school said mother could not go in. And my understanding from the record is that mother was outside in the rain with an infant. And this is not me saying to the panel that I don't wish they had found a way to accommodate that, but that did not justify mother's response, and it certainly wasn't a departmental decision.
How old was the infant?
I believe she was 2 weeks.
Virtual newborn.
Absolutely.
Out in the rain.
Absolutely. The record is unclear about whether that was necessary, and I'm not saying that the record proves it wasn't, but my understanding is that the oldest child, not to this care and protection, but an older child of mother's, had driven mother and the child to the appointment. So presumably, if the child being visited is still in school, mother and that infant could have waited in the car. It's unclear how mother was able to depart so quickly, because by the time the social worker arrived, mother had left. So it's certainly possible that the oldest child drove her away. It's indicated that he drove her there. This is not me suggesting mother should have kept the infant in the rain. This is me suggesting two things. One, how she handled it in the moment was inappropriate. But I think more important than that is what she did in the aftermath. When she and that youngest child were not in the rain, she called the program, she spoke to her son, she belittled him, she yelled at him, she blamed him until he was crying. And that, I think, is the bigger concern with regards to violating the conditional custody order. And again, whether or not mother should be in the rain with a newborn, absolutely she shouldn't. Whether or not that was a product of a decision that she made, that's another story. I think that it was. And it was not the department that denied her admission. The department wasn't present.
I see that's about your time.
Thank you, Your Honors.
Thank you. So I don't even dare try to pronounce your last name, so maybe you'll help me, please.
Yes, thank you, Your Honor. Good morning. If it please the court, my name is Christine Hamilton Quiros.
Quiros, good morning
Yes.
to you.
I am the attorney for the eldest appellee child, and I'm here today requesting that this court affirm the decrees, mainly because the admissible evidence was overwhelming, that mom has a very long history of anger issues and mental health issues and not being able to parent, refusing services, being difficult to work with, and the standard of review is the substantial deference standard. And this judge,
You think Mom loves her children?
do I think she loves the children? Absolutely. Personally, that's not in the record, but absolutely I do. So the substantial deference standard of review only allows an appellate court to reverse the judge's findings and conclusions when there's a clear error of law, or the findings are clearly erroneous, or an abuse of discretion has been made. In this case, the lower court judge did not do any of those. There was ample evidence that mom, she in fact refused, she just refused to engage in services. She did say that she had already completed services, which we do know that she did complete an anger management program, but that was way back in 2006, after she had been charged and sentenced to 6 months in jail for assaulting a person over 60. And subsequent to that, she had when she had gone to the incident that was spoken about earlier, it was at the request of the school because the child had they wanted to speak with her about the child making inappropriate comments to another student. When she arrived, they had to coax her and call her to come to the school. They'd had issues getting her to come to school when there were problems. She didn't want to come to the school. So when she got there, she was very angry, so angry that she made other children cry. Her presentation was that scary to the children.
Is there evidence in the record that Mom had some mental health issues?
There was evidence in the record that mom had mental health issues. She had testified to different mental health issues, and the judge found that her inconsistent testimony, her testimony was inconsistent about her mental health issues, but that her presentation to providers and to the department, along with her presentation at trial, was grave concern with her mental health being untreated.
Sure. Was she given services for her mental health?
I'm sorry, did she get services?
Yes.
She did engage in some forms of therapy, but she refused to provide releases and she stopped the therapy. She didn't think that she had an issue. She didn't think she needed to get therapy. She didn't think that she'd done anything wrong in any of her parenting since even her two older children who weren't a part of the care and protection. And she in fact refused. She said, there's nothing wrong with me. It wasn't my fault that the children came into care. I am who I am, and I'm going to remain that way. No one is going to change me, not even for the children. So the evidence of mom minimizing and denying her mental health issues and the way that her mental health and her anger issues affected the children was most disturbing, and the court did make findings as to that. Mom couldn't seem to understand how her defense of what she thought was being done to her inappropriately affected the children. She didn't seem to understand how that scared the children and made them feel afraid and not safe with her. And that angry behavior started way before this care and protection, continued through the care and protection, and even at visits.
What do you point to in the record that suggests the children didn't feel safe with Mom?
Well, the children, when the eldest child in particular, at a couple of visits, told the social worker that he was afraid of Mom, that when she yelled and was angry, he was afraid of her and he didn't want to stay at the visit. He'd asked to leave twice, I believe. He'd refused a perfume bottle at his head. He'd been found multiple times wandering in the street with no coat. He'd gone to a neighbor's house for breakfast, and when she found out he was there, she hit him on the head. made him leave the home. So her actions were not only of concern to the judge, but the eldest child had made several comments to the workers, and the middle child just refused visits at one point.
I see that's your time. Thank you.
Thank you.
Attorney Niles.
Good morning. May it please the court, my name is Shari Avalon Niles, and I represent the appellee children, sisters M and S. S, the youngest, was removed at birth due to concerns with mother's two older children. At the 72-hour hearing, she was returned to her mother on condition. Mother breached those conditions.
What was the condition?
The conditional order?
Yeah.
She had to behave in an appropriate manner. She had to taper her aggressive nature.
What does that mean, behave in an appropriate manner?
The concerns with mother is that her aggression were not normal aggression in terms of how my sister attorney remarked. Mother's aggression was demonstrably different. She was very outspoken, aggressive to the point where it affected not only the children, but every service provider she came in contact with.
For example? For example?
In the record, there were times mother would yell and scream at the social workers. She called the social worker, may I be frank in terms of what is in the record, Your Honor? She called the social worker very discriminatory words, like coon and different things that was speaking towards the social worker's race and color. She was aggressive in the sense that she would say things like, if she didn't like how she was spoken to, she would say things like, don't mess with me, don't mess with me, don't start this. And she would be very aggressive and say expletives, which I will not mention at the court. So I believe that was her manner in terms of how she related to others.
And so
It could be both, because we live in a society. Life is not one-dimensional, Your Honor. It's multidimensional. So we live in a society where we are judged by others, right? We can say things, but sometimes it's how it's said that we can get our point across. And I think with mother, somewhere along the line, that type of attitude was never tapered with her. So she believes that she can just go into society and say and speak however she wants to whomever she wants.
beyond the finding of unfitness, does Mom challenge any of the court's ruling findings?
No, all 251 findings and 43 conclusions were undisputed. It was never raised, mother never challenged them. So in this case, there is no reason why mother should be bringing up any of these issues right now at the appellate level.
Attorney Niles, thank you very much.
Oh,
Matter
thank you.
stands submitted.
Thank you. Thank you.
The next case that we'll be hearing this morning is 2023 P1045, David Gold and others versus the Rutland Zoning Board of Appeals and others. Good morning. Paul Revere?
Yes. Yes, Your Honor. Good morning, members of the court. Paul Revere on behalf of David Gold and Carolyn Streeter. Mr. Gold and Ms. Streeter represent a group of individuals who are residents of the town of Rutland who have concerns about the permitting of a cell tower in their neighborhood. I do a lot of complex environmental and real estate development permitting. This is not a complex case. This is a very simple case. In fact, I thank my sister for bringing a motion for judgment on the pleadings immediately because it brought up the sole issue that is the basis of the complaint and of this appeal. As I put it very simply, and it's in my brief, does the granting of a variance change an otherwise non-conforming cell tower into a cell tower that complies with the Rutland zoning bylaw?
Can I ask this, Attorney Revere? This is where I'm a little bit stuck. Am I incorrect in seeing the variance as exempting the cell tower from the requirements rather than making it compliant with the height requirements?
It is correct. A variance is a site-specific change to the zoning bylaw. I always describe it, it's very anti-democratic because the town meeting put together a bylaw and said, thou shall do X. And a bunch of board members who were appointed said, well, you don't have to do what the town meeting said.
I want to let you finish my Judge Hand's question, but just so I'm clear, there was no appeal to the variance, right?
That is correct. In fact, I wish they had asked me when the
Not in
variance had
mind
been
as you
issued.
finish
Yeah.
your answer.
No, the variance is in place, was not appealed on a timely basis.
But if that's the case, and it's a one-time deviation from what otherwise the bylaws required, if that's what the variation is, I'm not trying to put words in your mouth, but is that correct as to what
Correct.
you're explaining? Then why does that deviation not apply globally to that particular site as to the other?
And they work in tandem. Section 53 is the height requirement, which it ends up being, in this case, would have been 75 feet, but it needed a variance, made it 110 feet. The applicants applied for a variance, received a variance from that. Then they had to apply for the special permit. The special permit is a completely separate district. You can obtain a special permit and build a cell tower if it complies with the height requirement of Section 53. That's
But if the
51.
variance is an exemption from that requirement, why doesn't the exemption apply under the separate section? Understanding that they're separate sections.
Well, because remember I mentioned variance as being anti-democratic. I think it's fairly straightforward that the town meeting passed Section 51 and said you can get a special permit, and a special permit is, I quoted the language in here, but it's generally thought to be something that is potentially acceptable. The town meeting said it's potentially acceptable to come here with a special and get a special permit, but only, I'll say, if you're 75 feet high, if you comply with 53. 53 was, the height requirement was completely waived here. And I think it eviscerates the purpose of the passage of Section 51, okay, to say, well, the zoning board can ignore Section 51 completely and then, or 53 completely, pass our decision on how high is good, and that allow them to slip through the easy path of Section 51. I think Judge Tingle asked me in Worcester, well, what do you think they should have done? And my answer was they needed to apply for a variance from both provisions, the height provision and from Section 51.
Help me understand that. I'm not sure that I follow that. So they get the variance on the height,
Right.
right? And then you read the first sentence of the permit process, which was you have to be in compliance. So essentially, with the variance, aren't they in compliance?
No, they're not. In fact, the Mendez case, and I laugh, I have to say, I actually know Mrs. Mendez. It was her husband who filed it. And there's another case I cite, Pendergast, and I actually know the Pendergast family. But the Mendez case deals with a property in Barnstable, I drove it by the other day, which was given a use variance. And while it involves pre-existing non-conforming uses, it had a use variance, and then that area was differently zoned, and the owner of the property tried to change the use of the property by getting a special permit saying, I'm a pre-existing non-conforming use. And the court said in the Mendez decision, you're not a pre-existing non-conforming use, okay? You were never in compliance with a bylaw. You had a variance to allow you to be there, and so you can't use the Section 48, Section 6 non-conforming use provisions to change your property, okay? And I think that's very similar to what we have here, is we have a variance. Normally, a non-conforming use is something that is in compliance with a bylaw, and then the bylaw changes, okay? And it's in non-compliance, so it becomes a pre-existing non-conforming, use, or it can also be a dimensional problem. You know, you're too close to the sideline. But it's pre-existing, so you're allowed to continue it, but you're not considered to be, you might have been, a property with a variance is not considered to be a non-conforming use for the grandfathering provisions of 48.6 because it was never in compliance with the bylaw. Here, I think that is consistent with my proposition that obtaining a variance does not allow you to say that you are in compliance with the bylaw. In fact, and I've cited two, additional cases on that. There's the Seguin case, which again, there is no case on point, by the way. There is a Superior Court case that my sister cites in her brief. But the Seguin case involves something called an approval not required subdivision. That is the ability to divide a property into two separate lots without having to comply with the subdivision control law, okay? To obtain an approval not required endorsement on your plan, you need to have each lot having sufficient frontage as set forth in the zoning bylaw. In the Seguin case, the person said, well, I have sufficient frontage under the zoning bylaw because I have a variance for the frontage amount under the zoning bylaw. Again, as I started this argument, there is no case right on point, but that is very similar to applying whether you're in compliance with a bylaw or not in compliance with a bylaw.
But in Seguin, is that apples and oranges where you have the compliance with there's an issue with the bylaw, but then an issue with the statute? Is that different than bylaw to bylaw?
I don't think so. But I think I said it more for the interpretation that this court has consistently held, or these courts and the SJC, held that compliance requires you to be in compliance. In fact, I cite the Cumberland Farms case. There's a section that says, Section 7 of the Zoning Act says that if you have a property that was built without a building permit and no enforcement is taken over a certain period of time, you're allowed to keep that property in location, or actually even without a building permit. If you're also given a building permit, you have another statute of limitations and you can have an unlawful use if the use was in the building permit. But the Cumberland Farms case says even though you're exempt from enforcement, you're outside of what's in zoning, and there's nothing that can be done, you are not in compliance. Again, Cumberland Farms is not on point. As I said, there is no case on point at any appellate level, but merely the appeals court and the SJC has consistently interpreted a zoning bylaw to say in compliance means you're not subject to an exemption. Here, as I started my argument with, and there's really, I think, not much more to say, variances changed the term of the bylaw. They changed one provision.
But don't we have to assume that when the town enacted Section 51 about special permits, they knew about Section 53 that permitted a variance for a height requirement? And therefore, your argument that they should have also applied for a variance from the special permit requirement ignores the fact that the town enacted both bylaws.
Well, let's step back there, okay, because a little unpack this. First of all, Section 53 says nothing about a variance, okay? The variance provision comes out of, I believe it's Section 10 of the Zoning Act, okay, which allows a zoning board of appeals to apply, when you meet certain very strict criteria, essentially conditions that are unique to a lot that are not unique to other properties in the zoning district, et cetera, et cetera. So the variance provision, variances apply across the board to any provision of a zoning bylaw. But if you follow your reasoning that any provision can be varied and the variance can make you in compliance with a bylaw, it essentially makes variances overrule any bylaw provision. To me, a variance is only applied for the provision for which you seek an exemption from and meet its strict criteria, okay? So that's the way I look at that, and I think Mendez completely supports my argument that a variance doesn't make you conforming.
It makes your non-conforming use permissible.
Permissible, but the language says complies with the bylaw, okay? You know, as I said, there's no case on point. We're walking around the edges of it at all. You know, Mendez is not on point, Sagan's not on point, but at the same time,
Would
I
you say
think
it makes you exempt from that?
It makes you exempt from 53. It doesn't make you exempt from 51, because you don't comply with the bylaw. You just have an exemption from the bylaw, okay? And that's the Mendez decision. As I say, I wish I could point to a case and say, this is the case that's right on this. I can't. There are
Might be able to by the time we're done.
Yes, I know you have another land use case coming up here, the Oyster Pond one, which I may stick around to hear because it's fascinating, but we may have one by the end of this matter. Thank you very much.
Appreciate your time. Attorney Andrews Long?
Yes. Good morning. Attorney Danielle Long on behalf of my client Blue Sky Towers, and I'm also arguing on behalf of AT&T as well as the town. I agree with my brother. This is a very simple case. It was a simple case down below. It's a simple case on appeal. There's one single reason set forth in the complaint as well as this appeal as why the plaintiffs are saying this special permit decision for the proposed cell tower should be overturned. And that is the fact that the height of the proposed cell tower does not comply with Section 53 of the bylaw, as evidenced by the fact that my client obtained a variance. So basically what the plaintiffs are arguing is because the applicants needed and obtained the variance for this project, the tower as a matter of law does not comply with the height requirements of the bylaw, and therefore the local ZBA did not have the authority to issue the special permit. That's how I'm...
Notwithstanding the exemption.
Notwithstanding the exemption. That's how I'm understanding my brother's argument. So, in fact, the argument is the opposite. As a result of the variance, we did comply with Section 53, the height requirements of the bylaw, and it is that simple. To sort of follow my brother's argument, it sort of gives no rhyme or reason or purpose whatsoever for the statutory animal of a variance. The whole point of a variance, it's a waiver of local legislation, correct? It gives the local zoning boards the discretion to waive or find exempt certain provisions of a bylaw. I think what the misunderstanding here is, as a result of obtaining the variance, you are satisfying that particular requirement of the bylaw.
What's your best case for that?
So there's no appellate level cases exactly on point, and quite frankly, I think because this is a very unreasonable position to take, because the position is basically that there's no point of a variance. The Superior Court case that we cited, this Lemieux v. Ramsey, which was also out of Worcester Superior Court, is exactly on point, just except with respect to the reversal of the parties. There we had, the project was they were trying to convert additional rooms into a third apartment, and they needed a variance for the dimensional requirements of that project. Plaintiffs obtained the variance, was not appealed, just like in our situation, and then applied for the special permit for to obtain, the special permit, to make this third apartment. The plaintiffs argued that to the extent the dimensional requirements applies to the proposed change, the variance they obtained satisfied the dimensional requirements. The defendants countered with the argument that by its very definition, a variance constitutes nonconformity, which is what the plaintiffs are, exact same position the plaintiffs are taking here. The court, however, knocked that argument down in Superior Court and pointed out that the very essence of a variance is to exempt a party from the requirements of an applicable bylaw. And the court further held that the plaintiff satisfied the dimensional requirements of the bylaw as a result of the variance. In conclusion, if a party obtains a variance, the threshold inquiry of whether the proposed change conforms to the applicable bylaw is satisfied. And I think it's important to note that that court said they were not aware of any other cases that held otherwise. And I think that case was 2006. I mean, we've all shepherdized it since then, and there are no other cases that hold otherwise because that's not the law. Again, what the plaintiffs are basically arguing here is that a variance is obsolete and has no purpose. And I think there was an inference that, Section 51 needed to specifically state that we could obtain a variance from the requirements of Section 53. This is not a use variance. So, I mean, in those particular situations, Section 10, 40A, Section 10, again, statutory, says, that if, you can't get variances for uses unless there's a specific provision in the bylaw that you can get a variance for a specific type of use. So this is, I think it is undisputed. This is not it's a dimensional variance. As far as the cases cited by my brother, again, I in all due respect, I completely disagree. They are in opposite. The Mendes case actually had to do with whether a use that began under a variance had the status of a non-conforming use, because in that particular case, it was not a non-conforming use because it was never a legal use, and they kept expanding their use through variances, and then the bylaw changed and they weren't able to obtain use variances for what they were doing, and they tried to pass it off as a non-conforming use so they could go the special permit use, the less stringent path, as opposed to they would have need to seek a variance, which is a much higher standard, and that is what Mendes is about. I've briefed it thoroughly in my brief. The Seguin case, which had to do with the subdivision control law, basically, that was whether you could use a variance to bypass the statutory requirements of the subdivision control law, which is very different than the issue here, is whether a local variance can, exempt you from the provisions of a local bylaw. The subdivision control law is statutory. It's a state law. You can't use a variance to bypass those particular requirements. Again, completely an opposite. And also there's various other cases cited by my brother in his brief. Again, the 48 Section 7 is the statute of repose, and those cases all deal with enforcement of non-conforming uses under the statute of repose. So in the end, I think, it is our position, and I think it's well supported in law, and there's no other law to contradict our position, that the cell tower does comply with Section 53 height requirements of the bylaw as a result of the variance. To hold otherwise, you're negating the very purpose of a variance. So I'm not sure under what my brother's arguing what circumstances you could even use a variance for. What this really is, I think, is they failed to appeal the variance, and they're trying to get a second chance at that. And, that sort of ship has passed, and, it's a very simple issue, and it's the exact reason and purpose for what a variance is. So therefore, we request this court to uphold the Superior Court's decision and just dismiss all counts of the complaint.
Interesting issue, argued well by both sides. Appreciate it. The matter stands submitted.
Thank you.
Next matter on our list is 2023 P0765. Keith Barnett, trustee of Oyster Pond EP Trust and others versus Michael D. Myro, trustee of Botar Realty Trust, RAB and another. Attorney Ellsworth?
May I proceed?
You may.
Good morning, and may it please the court, Felicia Ellsworth on behalf of the plaintiff's appellants. The issue in this case is fairly straightforward, despite the tortured history of the matter. The question is whether the former bed of a great pond is owned by the Commonwealth.
So I'm not sure that that's the issue. Let's start with the issue is whether this is properly before us.
Happy to start there, Your Honor. So the appeals court, this case has been on appeal twice. The first decision, the Supreme Judicial Court in White versus Hartigan, noted that the question of whether the issue of Great Ponds was adjacent to the case but didn't decide anything related to Great Ponds. The case was sent back for a remand trial on prescriptive easement. After the land court decided adversely to the plaintiffs, a panel of the appeals court reversed in part that decision and reserved in footnote 7 of the 2019 appeals court decision whether or not there was an issue related to Great Ponds. And footnote 7 of the appeals court's decision says that the parties had stipulated that certain ponds, Oyster Pond and Big Job's Neck Pond, were Great Ponds, and that the appeals court assumed, as did the parties, that this was the defendant's land as opposed to land of the Commonwealth that was before the...
What do you say about your opposing counsel's suggestion that that footnote indicates that the issue was not litigated below?
Well, I think with that footnote, it is true that it wasn't litigated in the first trial as to prescriptive easement. It was raised as a sort of assumption, and the question about which of these ponds fell within the Great Ponds or not was something that was stipulated to. In the third trial, the trial that we're now on appeal here from, the question that was sent back to the land court is whether or not the plaintiffs had used a strip of land in a manner that was continuous enough to establish a prescriptive easement. So only one of the prescriptive easement elements.
Tried on that limited issue.
Well, a necessary predicate to whether or not we can obtain a prescriptive
You agree
easement.
it was tried on that limited issue?
I agree that it was tried on the question of whether we were entitled to a declaration of a prescriptive easement and an injunction against the defendants interfering with our right to use the land in question. And the judgment appealed from here denies that injunction and refuses to issue that declaration.
And the court commented on the argument that you're about to make with us today, saying he's not convinced that it's properly before him, but he touched on it. I think it was the last piece that he had in his decision.
That's correct. And it was properly before him because, for the reasons I've
So
just...
that's your position.
My position is that inherent in the remand, inherent in the question of whether we attained a prescriptive easement, of course you can't obtain a prescriptive easement against the Commonwealth. And so a predicate question is whether the defendants own the land in question or whether, as we posited,
But he didn't
it's the
decide it
Commonwealth.
on that issue, did he?
I'm sorry, Your Honor?
He didn't decide whether you had a prescriptive easement based on who owned it. He decided it on how you used it, right?
Well, I believe it was decided, it was both argued in the alternative and decided in the alternative, right? He did not side with us on the question of whether we had obtained a prescriptive easement, and also went on to conclude, although he did note that he wasn't sure if it was before him, that's of course correct, that even if that issue was before him, he disagreed with the legal theory that I'm advancing in terms of the Great Ponds. Right. But I will say that it was both, I believe, as I've articulated, within the scope of the remand because it is a predicate question, and also that it was pressed and passed upon below. So we raised it in our joint pretrial memorandum, we raised it in our opening statement. There was testimony from both experts as to the question of the list of Great Ponds, the fact that Job's Neck Pond was on that list. That testimony came in without objection from the defendants.
But I'm sorry if I'm asking you to repeat something you've already said, but when you said you was pressed below, that was the same case in which the footnote appeared that suggested it wasn't litigated?
No, I'm sorry. I mean, it was pressed in the trial that we did 2 years ago in the land court on this, the third remand from, or the third trial, second remand from this court. And I would also submit that defendants have made arguments that there's certain evidence that they would have put in had the Great Ponds issue, in their view, been properly before the court. Again, they had that opportunity to put that evidence into the record in front of Judge Speicher in the case below. It was raised in the opening statement. They raised in their opening statement the type of evidence that is now raised in the appellate brief that they suggest could have been presented about ownership of the pond prior to 1640 and about the question of the acreage of the pond, but they chose not to put any of that evidence into the record. That's a decision that the defendants made. That doesn't mean that they didn't have the opportunity to do it. If I can go on and talk about the merits of the issue, since the judge passed upon it, there is a long line of cases that talks about Commonwealth ownership of Great Ponds being not just limited to the Great Ponds, but also to the water that lies on, the land that lies underneath it, and the former beds of Great Ponds. That is,
How do your clients have standing to assert the Commonwealth's rights in this matter, where the AG's office has declined to intervene?
So I would say two things. I don't think that we're asserting the Commonwealth's rights. We have sought an injunction against the defendants interfering with our rights to use this particular portion of beach, and our rights could be either because of the claimed prescriptive easement or as members of the public who can use it if it is owned by the Commonwealth for the benefit of the public. I point the court to the Potter versus Howe case, which is a case with two private parties in which the SJC determined that in fact a strip of land that was disputed by the parties was owned by the Commonwealth in trust for the public under the colonial ordinances. So I don't think it's necessary for the Attorney General to be a party or to participate in order for a court to make a determination that in fact this land that we're talking about, beach land here, is on the former bed of a great pond. That fact is undisputed. And then the legal conclusion that flows from that fact is that it is owned by the Commonwealth in trust for the public and not owned by the private landowners who own the land surrounding the great pond. Now, I'd like to talk about the Kubik decision, which is this court's decision in 2020, in which a similar issue was raised. I'd point the court to the fact that in that case, the Attorney General both sought to intervene, was denied because I believe they were viewed to be too late by the lower court judge, instead filed an amicus brief in which they expressly disavowed ownership of that land. And the court, and I know the panel's familiar with this case, the court said in footnote 21 of the Kubik decision, we do not know how if this analysis would be different had the Commonwealth not disavowed their role here. So I think that the Kubik case, while it obviously has some, is informative as it addresses some of the same issues, it does not control the question here where the Commonwealth has not come in and expressly disavowed ownership of this particular area of land. And in fact, I would note that there is an Attorney General opinion letter from 2013, and it's in the record. It was submitted in connection with our post-trial briefing, in which the Attorney General, then Attorney General Coakley, submitted an opinion to the Senate in connection with a bill that was being considered, and noted that the former bed of a great pond is the property of the Commonwealth and not the property of any private littoral landowners that may be adjacent. Your Honor, you look like you had a question, but
I was going to ask you to talk a little bit about whether or not the issue of whether there was 10 acres to begin with is in play.
I think it is, well, I think it is in play because I think the issue of the Great Ponds was properly before the land court. What we put into evidence in front of the land court to establish that Job's Neck Pond, that Big Job's Neck and Little Job's Neck Pond are great ponds, was testimony from Duncan Fitzgerald, a coastal geologist, who talked about the Mass DEP list of great ponds on which Job's Neck Pond appears. He testified to that without objection. He also testified, as did defense witnesses, both their expert witness, Leslie Field, as well as one of the defense fact witnesses, that Big Job's Neck Pond and Little Job's Neck Pond had previously been a single larger pond, and there is a map in the record that shows that. It's at Appendix 337. and testified to the fact that this was on the list of great ponds, which is something that this court and the SJC has looked to as evidence of the fact that something is in fact a great pond.
Do you think that that makes it dispositive?
I think that that shows that it is a great pond for purposes of the factual question of whether the beach in question over which that we're discussing here sits on the former bed of a great pond. There's no question that the beach in question sits on the former bed of a pond. No dispute, I should say, about that. That was undisputed. And the evidence at trial, I know that the defendants now are suggesting that there's some evidence they may have wanted to introduce to try and dispute it, but the evidence at trial was that the area in which this beach now sits is the former bed of a great pond on the Commonwealth DEP list of great ponds.
So they didn't offer that evidence because I don't know that they felt it was pertinent to the argument that they were making at that time, right?
Well, again, Your Honor, we noted in our joint pretrial memorandum that there were disputed facts as to whether or not these were great ponds, as to whether or not the beach was now sitting in the former bed of a great pond. Those are disputed facts in the joint pretrial memorandum. In the opening statement at trial, we indicated that one of the issues...
Is it in the complaint?
Excuse me?
Is this argument in your complaint?
It's not in the complaint, but the complaint can be conformed to the evidence under Rule 15b, and the court accepted the evidence. We previewed, again, in the joint pretrial memorandum, in the opening statement, and throughout the trial, with evidence and exhibits, that this was an issue that was going to be tried before the land court. And much of that evidence...
Say it with such force.
Because I have conviction, Your Honor.
Yeah, I know that's part of it.
And I would say the evidence came in without objection. I understand there was a statement in opening that they weren't sure that this issue was before the court. The testimony of Dr. Fitzgerald came in without objection. He was cross-examined by defendant's counsel about the Great Ponds list, about this question, without objection for me, because of course I thought that it was properly before the court. This is a classic case where it was pressed and passed upon below. It was within the scope of the remand from the appeals court, both because I think the court reserved on it in footnote 7 based on the stipulations that had been made at a previous trial, and because in order to make out our claim of prescriptive easement, we needed to first show that it was the defendant's land against whom we were trying to move. So what we're here on appeal on is this question of, I think, with the facts undisputed or fairly undisputed as to where the beach sits and as to the nature of the land on which the beach sits, which is Commonwealth-owned bed of a great pond, what does the law say about who owns that particular area of what is now dry land? And I think that the Herrick decision, Potter versus Howe, and the Vineyard Grove decision, all from the SJC and appeals court, all indicate that the former beds of great ponds, even if there's a private littoral landowner, that land is owned by the Commonwealth and benefit for the public. And that compels the conclusion that the beach in question here, under Big Job's Neck and Little Job's Neck Pond, is owned by the Commonwealth in trust for the public. And so I'd ask that the court's decision to the contrary be reversed on that ground. That's the legal argument that I think we're making. And again, the Kubik case talks about both the opinion of the justices, which is an SJC advisory opinion in connection with another Senate bill, which on my reading suggested an open question of how the Great Ponds doctrine and the colonial ordinances interact with the common law of littoral ownership. But what the Kubik decision did essentially was put this issue to the side in footnote 21 because of the Commonwealth's express disavowal, and then go on and apply the general law of littoral land ownership, which is well known to this court and is really not in play in this appeal, because here we're talking about the colonial ordinances which trump the common law. I'm happy to answer further questions that the court has.
Hearing none, Attorney Ellsworth, thank you very much.
Thank you very much.
Appreciate it. Attorney Hurley?
I'm Attorney Pusilowski, Your Honor. Attorney Hurley is going second.
Thank you.
And I appear on behalf...
Your time 10 and 5, is that correct?
Yes, that's right, Your Honor. I appear on behalf of the Kohlberg defendants. The argument that the plaintiffs make today is not properly before this court, nor was it before this court in 2018, nor the SJC in 2013, nor before any of the three land court judges who heard this case.
Tell me why.
Number one, they have never filed a count in a complaint seeking a declaration on this, and they have never had a prayer for relief seeking the same. More importantly, Your Honor, it was agreed among the parties that this issue was not before Judge Trombley.
Where?
Well, you see in his summary judgment opinion that appears at the plaintiff's addendum at 105, he says the parties agree that the issue is not before the court. But more importantly, there is an explicit agreement among the parties, and this is how it arose. On October 16, 2009, the plaintiffs filed a motion to supplement expert testimony, and that was expert testimony of their coastal geologist, Lester Smith. And the supplementation itself was quite innocuous. It said that he would testify that the barrier beach had migrated onto the bed of the Great Pond. We all agree that that's true, it's non-controversial. However, in the accompanying motion and memorandum, the plaintiffs say that he would testify that it migrated on the former bed of the Commonwealth Great Pond, which set off alarms with us. Despite the fact that the pretrial memo, which was filed on October 29, did not mention the Great Pond issue, the plaintiffs agreed that the only issue before the court was prescriptive rights. When Judge Trombley allowed that supplementation at the pretrial on 10/30, Mr. Hurley and I each filed a motion to preclude testimony on the ownership issue. That was November 30. On December 4, the plaintiffs filed an omnibus response, not an objection. And this is what it said. Plaintiffs hereby respond to defendants' motions in limine to exclude evidence pertaining the ownership of the large ponds north of the barrier beach. Plaintiffs acknowledge that the issue of legal ownership of the barrier beach sections of the beach and the ponds is not presently before the court. Plaintiffs agree not to offer opinions that the Commonwealth is the legal owner of portions of the beach at issue, and they also say that legal ownership of several barrier beach sections of the beach incident to the ponds will not be litigated at trial.
What page is that at again, did you say?
Well, it's not included in the appendix because when we did the appendix, we thought this was a conventional appeal on the prescriptive rights issue. It's only when they pressed this issue of Commonwealth ownership, as to which there was no evidence at trial, so we had not been worried about it, that we needed to go back through the tortured 20-year history of this case to locate the places where they had said otherwise.
Do I understand you correctly? I apologize for interrupting. Do I understand you correctly say that what you just read is not in our record?
It's not your record. It's in the record appendix that was provided to the SJC in 2012.
Okay. Can we take judicial notice of that?
Yeah.
What do you think about that?
I certainly think you can. It's part of the record, Your Honor, and we'd be glad to provide copies. In fact, we could provide the voluminous appendix from the first and second cases if the court preferred.
Not sure if that's necessary.
Yeah. Let me just speak a little at trial. Ms. Ellsworth raised the ownership issue in her opening.
Sorry to interrupt. Do you know what page of the, I assume you mean in White v. Hartigan record
Yes,
appendix?
Your Honor.
Do you know what page it is?
I don't, but I can
Okay.
provide that, Your Honor.
I don't think that's necessary.
In her opening, Ms. Ellsworth raised the Commonwealth issue, and both Mr. Hurley and I objected in our openings. The testimony was not probative on the issue in any case because Dr. Fitzgerald testified as to the Great Ponds list, and the Great Ponds list, he admitted on cross-examination, was only jurisdictional. It speaks nowhere about ownership. In fact, it could not be about ownership because on the list is the Watuppa Great Pond, which the SJC found to be privately owned in 1891.
That's your time.
On cross-examination, Your Honor, he
Now hear
admitted,
from Attorney Hurley.
Good morning, Your Honors. My name is Brian Hurley, and I represent the trustees of the Pahargana Trust. I should note from the outset that the Pahargana Trust is a defendant in the cases and didn't have any claims to allege. So I'm not sure when Ms. Ellsworth chides us for not having asserted claims, that wasn't really our place to do in this particular case. I have been with this case since 2004. When it started, I actually had brown hair. But it's gone on so long and so many twists and turns over the years. I've been twice to this court. This is my second time, and once to the Supreme Judicial Court, which has been a great experience for me.
Can I ask this question before you get underway? What do you say about Attorney Ellsworth's argument that the question of ownership of the bed of the pond on which the beaches now sit, on which the beaches now sit, is an essential part of even a narrowly construed remand?
Your Honor, I don't see any language at all in the remand that would suggest that that was an issue in the case. And if you looked at the joint pretrial memo that we filed in the case, and that is in the record, I don't have the page number in front of me, but the joint pretrial memo identified 3 very specific issues in the case. And let me read them because I wrote them down and I thought it was important. Whether an easement by prescription established through beach trying to read my writing here, runs with the lands. Whether the plaintiff has established continuous use of the Job's Neck Beach during the prescriptive period, and whether the plaintiff's lack of access to any prescriptive easement they may have acquired over part of the Job's Neck Beach has been extinguished due to frustration of purpose. So the whole point of the appeal had to do with prescriptive easement issues. It had nothing to do with ownership. And if you go back in the history of this case, and I lived through this, and Mr. Pusilowski made some reference to it, in 2009, we all agreed that ownership of the ponds was not an issue in the case. It was not an issue that was going to be litigated and decided. And as a result of that agreement, the Attorney General chose not to participate in the case. Now, if it were really true that that issue was raised at this point in this case, then clearly the Attorney General would have had to have been brought into this case, and they weren't, because it's the Attorney General that has the claim for the people of the Commonwealth of Massachusetts with respect to ownership. It doesn't lie in the plaintiff's mouth in this case, and they didn't do that. So it's not accurate to say that that issue was properly before the court. It wasn't pled. It wasn't listed in the issues that would be considered on appeal, and it was missing a fundamentally necessary party.
So am I understanding correctly that your view is the question potentially could be prescriptive easement, yes, no, and a separate action, maybe, if to determine whether there was
possibly, but if
ownership, what the ownership of the pond was?
If that were the case, the Attorney General would have to be joined, and in that case, we would argue, because we think the evidence would support this, we would argue that the Commonwealth can't prove their ownership. The fact that it's on that list is really meaningless. I mean, all that means is that they have 10 acres. That list doesn't purport to identify the owner of each particular property. And so it's not really important other than to say that it's 10 acres. And we believe that the evidence would show, if there had been a trial, and if Ms. Ellsworth had actually tried this issue before the land court, we think the evidence would show that the Commonwealth doesn't own Job's Neck Pond, because it had been conveyed out in the mid-1600s, some 40 or 50 years before Martha's Vineyard became part of the colony of Massachusetts. And it was only when they became part of the colony of Massachusetts that the colonial ordinance with respect to the ownership of Great Ponds came into effect. So if we had actually had a trial in the case, if we had actually asserted some sort of issue with respect to ownership of the pond, which we didn't, we think that that issue would have turned in our favor. And most importantly, the Attorney General would have had to be part of the case. They bowed out of the case in 2009. 1999 only because we agreed that we wouldn't litigate the ownership issue at that time. And it was only as a result of that stipulation that they stepped back. So I disagree completely that that issue is properly before this court, the ownership of Job's Neck Pond. That was not part of the remand. The remand was limited to the question of whether or not they had established a prescriptive easement over the portion of the beach that was adjacent to that pond and nothing else. They lost on that issue. They attempt to raise an issue that really doesn't lie in their mouth. It wasn't part of the pleadings, and this court should dismiss this appeal on that basis. If there's any questions, I know this is confusing, and if you have any questions, I'd be happy to answer them, but I think those points really are self-evident and militate in favor of dismissal of this appeal.
Parties reserve their rights with regard to whether Paquah Pond should be considered a great pond and questioned whether Little Job's Neck Pond is a great pond.
And we still reserve those rights. We wanted to make clear that we weren't having those issues adjudicated in this case. They might be adjudicated in some other case, some other day, with the Commonwealth as a party, but they weren't as part of this case, and that's why that language is there.
Anything additionally at this time?
No, thank you very much for your time.
Stand submitted. Thank you very much. Excellent job. Court's going to take a brief recess.
Court, all rise. Court is now in session. Please be seated.
Good morning.
Good morning.
The next matter on our list is 2023 P 1099, Tom's Ashland Auto, Inc. versus Safety Insurance Company.
Good morning. Charles Vaca for the appellant, Tom's Ashland Auto. So this is a matter of interpretation of how to use the Massachusetts auto insurance policy, in my opinion. There's a question of whether or not loss of use is available in the set of facts here, and it's our contention that it is, and there's been quite a few cases over time dating back to the Antolco case that offers loss of use as a remedy. But most importantly is the balance, so to speak, or the use of Part 7, which usually pertains to a first-party claim, and Part 4, which is a clone of MGL Chapter 90, Section 340, under Part 4, which is usually found under third-party claims.
Can I ask one question before you get started on that?
Go ahead.
It's maybe a minor point, but doesn't the application of coverage under Part 4 depend on the insured's being legally responsible for the accident?
Yes, it does.
So in this case, the accident occurred, if I understand correctly, when the Highlander was parked somewhere in Wellesley, is that right?
I believe so.
How was the insured in that case legally responsible for that accident?
Because the person was held responsible with the automobile under his or her care.
So it's not a liability issue, it's a control issue?
It's a what, please?
Control, the issue of who has control of the car?
Yes, but it would be a claim under the Massachusetts auto insurance policy.
Right.
And in this matter, the motor vehicle in question was a rental from Tom's Ashland Auto to, I believe it was Dale Kildare.
So fault is not the issue.
I'm sorry?
So the fact that the car was unattended when it got struck, I'm not loaner, but the rental car was unattended at the time that it suffered the damage, for which Tom got paid on the damage, right? The car was restored to the
But under the
condition it
term-
was prior to the rental. The issue is that 25-day loss while it was being repaired.
Yes.
And they couldn't rent it during that time.
But under the terms and conditions that Kildare entered into with Tom's Ashland Auto, there was a loss of use clause there under paragraph 9, I believe, of the rental
I understand, but we're not
agreement.
suggesting in any way that it was Kildare's fault that the car got damaged.
Well, it was under the control and custody of Dale Kildare. And Dale Kildare
I mean, was it
had
parked in some place he
insurance.
shouldn't have parked it?
I'm sorry?
Was it parked in a location that it shouldn't have been parked at the time that it's?
I am not sure of that, Judge. So, so I know in reading opposing counsel's brief, there is the question of whether or not the insurance commissioner, and there's been a lot of discussion about exception 6 under Part 4. Well, frankly, I took a look at that. I even graphed it. And if any of you read exception 6, there is a lot of confusion onto what it really does mean. And one thing it does mention is that Part 4 in paragraph 6 prohibits any recovery on rentals. Well, I can tell you as a person who negotiates a lot of these, there is relief under this section for substitute transportation or rentals. So I know it's been brought up that this does not pertain to rentals, therefore Part 7 was used.
But the fact that your practical experience says that sometimes coverage is offered, does that mean that does that change the language of subsection 6 or paragraph 6?
I'm not certain what you're asking me.
Maybe I'm
Judge.
understanding you wrongly. Is what you're saying that notwithstanding the language that says we will not pay for damage to an auto which you rent,
Right.
that notwithstanding that language, your experience has been that insurers will still pay?
Yes, and
But
they,
in
fact,
any event,
I've act-
in this case, as I understand it, safety did pay for damage to the Highlander.
they paid for the repairs, Judge. They did not pay for the loss of use.
So you're saying that word damage in paragraph
And
6
they'll
means
tell
loss
you
of
that-
use?
And they'll tell you, Judge, we paid under Part 7, which is a first-party claim.
But so are you arguing that that word damage in paragraph 6 incorporates loss of use?
I'm saying that Part 4 incorporates loss of use. It says it right in the language.
Yep.
And like I said before, that's almost a carbon copy of the language you will find under 9340, under the general laws and statutes of the Commonwealth of Massachusetts. And what
So you,
I'm
I think,
tell-
we're starting to argue that the statutory language controls over the policy. Is that what you're?
Well, you know, it's interesting you mentioned that, Judge, because opposing counsel has cited the Colby case, and there's language in the Colby case that says that, exactly, that general laws and statutes do rule over what might be found in a policy or something otherwise.
But not under this specific section?
I'm sorry?
Is it under this specific section that Colby's talking about, under 34O, with respect to the
No.
standard insurance policy?
No, Colby was a case, a 1995 case, and I did not cite that in my brief only because, but I'm here today ready to talk about it because it was in opposing counsel's brief, which was subsequent to my brief.
Then maybe let me ask a question that might streamline it or not. But what authority do you rely on to say that in these specific circumstances, the commissioner's approval of the standard auto policy does not amount to his approval of the limiting language in paragraph 6?
I think what you're asking me is also in the Colby case, and it's under, let's see, I'm just looking for the page, page 806 of the Colby case. And in that, to paraphrase, but I'm reading it verbatim, it starts with the plaintiff is correct in asserting that, and then middle of the paragraph, Judge, it says, and the commission's interpretation of the relevant statutes, although not controlling, is entitled to deference. Well, the way I read that, Judge, is that what the insurance commission, yes, the insurance commission can make his or her opinion on interpreting the Massachusetts auto insurance policy, but it's not controlling. It's up for further review and scrutiny by the courts.
So here, where the policy provides collision insurance as required under 34O in two forms, as the compulsory coverage that includes the exclusion for, or that some read as including the exclusion for rental cars, and under Section 7, which is optional coverage that includes, that doesn't have that exclusion, but also doesn't have loss of use.
Right.
Where is the conflict with the statute?
Where does what
where does the policy conflict with the statute?
I'm not saying it conflicts. I'm
Okay.
saying that safety, and other insurance companies as well, Judge, misutilize the mass auto insurance policy. This was clearly a claim that was filed by Tom's Ashland Auto. It wasn't filed by Dale Kildea, but it was Dale Kildea's insurance.
But doesn't the definition of your auto matter? When you look, I understand your distinction between the first-party and third-party claims, but
That
here...
would pertain, in my opinion, Judge, if it was a first-party claim. If Dale Kildea had filed a claim with safety, yes, your auto, I believe, would have applied.
Didn't Dale file a claim with safety? Didn't Dale file a claim with safety? Wasn't his car being repaired, which put him in the position to have to rent a car?
No, Tom's Ashland Auto, this was a rental vehicle, Judge.
Why was he renting a car?
Why?
Yeah, Tom's Ashland Auto was not repairing Gildea's...
Because Tom's Auto Body, which is an affiliate,
Okay.
was repairing Kildea's car that Kildea owned.
The Jeep.
Right. So what do you do with Section 6?
What do I do with Section 6?
Yes.
I would love it to be tossed out the window, Judge, to be honest with you, because I think it's a lot of gobbledygook. And in fact,
Is that a legal term?
I'm sorry?
Gobbledygook, is that a legal term?
I believe so. It's not profane, right? I've talked to some people in the industry, and you know what they've told, in the industry, and they've told me that it was originally set up.
I don't know that that's really pertinent to our discussion today.
Okay, then I'll withhold that comment, okay? But
So
if you
maybe
read
can tell
it,
me, how do we get
I mean,
around
for
Section-
example, the clause, except for a private residence or garage, what does that mean? And also, it says to an auto or other property owned by you. The rental was not owned by Kildea, it was owned by Tom's Ashland Auto.
It says owned by you or the legally responsible person. That's what Section 6 says.
Okay.
I mean, we can't cherry pick the language. I mean, the language is what the language is.
But I'm saying this is a restriction also on a rental vehicle, which is our contention, was not the intent. So,
All right, and the best case for that proposition is what?
I'm sorry?
And your best case for that proposition is what?
Well, there's not a case that addresses the exception 6. Unfortunately, the cases that address the loss of use issue I've cited.
Yep.
You have the Antolco case, you have the Eight Bowls case, and you have the Skiffington case. The other thing that I wanted to address is, since this case came to light, there was a Gilloway case,
Sure.
which, Gilloway, I'm sorry, and that pertained to inherent diminished value. I found that case very interesting because the SJC, the Supreme Judicial Court of Massachusetts, allows for inherent diminished value on a third-party claim. But if you look at the Massachusetts auto insurance policy, there is no mention of inherent diminished value. In fact, I think it says we will not give relief or pay on any diminished value.
I have a hypothetical question for you. As I understand it, the district court interpreted, and safety interpreted the policy to mean that Tom's can be reimbursed for the damage to the Highlander, but not for its loss of use of the Highlander. What if there was another customer of Tom's who had a reservation to rent the Highlander during the 25 days that it was out of commission as a result of this accident, would that customer get loss of use too?
Would that customer?
Would you argue that that customer?
Well, that would make a stronger argument for us, because the vehicle, the rental was out of commission because of the damage. Tom's Ashland Auto was not able to lease out that vehicle.
And so that, you're saying under the policy that that other customer should be paid for the loss of use for the rental they were never able to get?
I'm not exactly sure what you're asking me,
You follow
Judge.
the hypothetical. The hypothetical is, okay, let's assume for the sake of discussion that during that 25-day period,
Right.
somebody else had reserved the Highlander. And because Tom didn't have the Highlander, because it was out of service,
Right.
that person who reserved it could now bring a claim saying, hey, I was planning on driving that Highlander for 25 days to go on a trip, and I can't go on it, so now I'm suing because I didn't have use of that car.
Well, I'm not really addressing that issue. I'm addressing the issue of the Tom's
That was
Ash.
a hypothetical.
I know that, but I don't see, in all due respect, Judge, I don't really see where that is relevant to the issues at hand here, because we're talking about the company that's leasing the vehicles, not the person that's going to be leasing the vehicle. That, I think, is a whole different conversation, Judge. To answer your question off the bat, I don't think the individual would have a claim, no. But in this case, it was Tom's Ashland Auto who was making the claim, not Dale Kildea.
We understand, Attorney Vaca. Thank you kindly. I think that's
All
your
right.
time, sir.
Thank you very much.
Thank you. We'll now hear from Attorney Bossy?
Attorney Bossy.
Bossy.
Your Honors, thank you very much. I represent safety in this case. It's a pretty straightforward issue. In fact, it was pretty straightforward when the district court judge heard it and when the two appellate division cases heard this. This is a situation.
The two appellate divisions of the district court.
Appellate divisions of the
Of course,
district
we're
court.
not bound by that, right?
I most certainly agree with you, Your Honor. You are most certainly not bound with it. But my point is simply looking at their analysis, and I think their analysis is correct, as pointed in our brief. This is a situation where you have an individual who they're involved in an accident. So the Tom renter, the safety insured, is involved in a car accident. And the car accident, so she gets involved in a car accident and the car goes to be repaired. That's an important part here, okay? So the car goes to be repaired at Tom's Auto Body. Tom's Auto Body rents a vehicle to her. Now, what's also important is that that vehicle could have collision damage waiver and things like that, because we've all seen that. The rental could have collision damage, because we've all seen that when it comes to a rental. You go to an airport, you rent a car. And the rental car, they ask you, do you want insurance coverage on the vehicle? Because that would pertain to that particular vehicle. Well, in this particular case, there's no coverage there, okay, on that rental vehicle. So now we come into that rental vehicle is involved in an accident, okay. And the accident itself, now they're looking for us, meaning safety, to pay for the damage done to that vehicle, which normally would be covered under that loss damage waiver analysis or whatever, but they want safety to pay for that. And safety does. And here's the reason why. Because it meets the definition of your auto under the policy, therefore it triggers collision coverage. And that's extremely important. So it triggers that collision coverage. These are two separate coverages. They have nothing really to do with each other. The collision coverage is there. The fact that this is a vehicle, it's rented because of the fact the safety insured vehicle's out of use. Now that doesn't change property damage coverage. It just doesn't, okay? Because if that vehicle had been rented for the heck of it, let's say the safety insured vehicle is rented for the heck of it. They want to use, you've seen these ones where someone goes out and they have a birthday or something, and they want to rent a Ferrari or something like that. And they say they don't get coverage on that vehicle. They just rent it for the heck of it. It doesn't meet the definition of your auto under the policy because it's not rented because the vehicle's out of service. That vehicle, there's no coverage. If that person crashes it crashes the vehicle, there's no coverage under the property damage coverage for it.
Are you making a distinction between collision damage and property damage?
Okay, and I think, yes, because I think there is, property damage, there is a distinction between that. There's Part 7, which is an optional coverage, and Part 4. Now, Part 4 is specific. It's a compulsory coverage that can have optional layers, okay? And so in this particular case, the statute, and I don't think there's any issue here, and it hasn't been raised. This is a 2016 policy. The insurance commissioner is the one who approves and drafts this policy, okay? And in that, the insurance commission, the statute specifically allows, and if you look at page 11 of our brief, it talks about 34.0, and it's in the appendix also. Property damage liability insurance is insurance containing provisions as prescribed in this section, among such other provisions, including conditions, exclusions, and limitations, as the commissioner of insurance may approve. Now, why is that important? Because then you look at the policy. The policy is actually approved by the insurance commissioner, and that outlines exclusions in the property damage coverage. If we go to, I believe in the supplemental appendix, it is SRA 38, and there are the various exclusions for the property damage coverage, all approved by the insurance commissioner. Okay, this isn't stuff that safety made up. This is stuff that's approved by the insurance commissioner. Okay, and the one here that is an issue is Part 6, to an auto or other property owned by you or the legally responsible person, similarly will not pay for damage to an auto or other property except for a private residence or garage, which you or the legally responsible person rents. And that's important here, because that's what we have here. They rented this vehicle, or has in his or her care, custody, or control. Now, I guess you can make the argument the car's parked someplace and it's damaged, and so it may not be in their care, custody, but they sure the heck is rented, okay? And it doesn't cover that. And to address the one issue about the garage, the reason why the garage is covered is because people unfortunately do hit their own garages, pulling their car into the garage and it hits that. I digress there, but that's...
So does it matter if Dale Kildare was at fault?
No, I don't, and I heard you, and I don't think so, okay? Because that's not really what the issue is here, at least in this particular case. I think what he was saying was that, well, they're legally responsible because they rented the vehicle for us, and there may be some contract that they have with them that make them responsible for the vehicle, okay? Okay, so that's fine, but that's really not the issue here. There is a specific exclusion under the policy that is something that's drafted by, approved by the insurance commission, and it's excluded. Now, the one thing there is no case law on this issue aside from those appellate division cases that we've talked about. And the one thing I want to bring up is this idea of McGilloway and these other cases. Unfortunately, I guess unfortunately, you're going to win some, you're going to lose some. I was involved in McGilloway, okay? McGilloway has nothing to do with this. McGilloway and these other cases that they're talking about don't involve an exclusion to coverage. There was a question under McGilloway and these other ones as to whether or not they were legally entitled, meaning someone was legally entitled to recover, a third party was legally entitled to recover diminished value when their car is completely repaired. Okay, that was what the issue was. And it wasn't an exclusion in the policy. This is a specific exclusion under the policy. Mind you, for something that had the renter actually just purchased coverage on the vehicle before, which they could have done, we wouldn't even be here today. But the policy, this policy, doesn't cover this damage. No one's saying, and to address, I think, Justice Grant, you had an issue about property damage. Listen, property damage coverage does cover, in circumstances, loss of use, okay? That can happen in a third-party situation, okay? So, for example, I guess in the rental situation we're talking about, Johnny Jones is driving down the road. He's involved in an accident, wipes out a third party's vehicle. The third party's vehicle can't be used. It's being repaired, okay? And it sustains, that individual sustains a loss of use of that.
But isn't Tom saying they stand in the place of the third-party individual? Isn't that their argument?
But that's not the, because here there's a specific exclusion because the vehicle is, you can't take this policy in a vacuum. They're looking for something that is more rights than what the insured would actually have. And that's not the case because of the exclusion. I mean, I don't want to belabor this, really. I'll answer any questions you want or any issues you have, but I think it's pretty straightforward and put up forward in the brief.
Hearing none, the matter stands submitted. Thank you.
Okay, thank you.
Thank you. You still Mr. Doctor. Our next matter is docket 23-2023 P1138, Department of Children and Families and Another versus Mother and Another. I believe the appellees will be splitting or sharing their time, 10 minutes for Attorney Gallup and 5 minutes for Attorney O'Brien. Good morning, Attorney Newbill.
Good morning, Your Honors.
Ready when you are.
Thank you, Your Honors. May it please the Court, Attorney Lucas Newbill on behalf of Appellant Mother. This case is about a lightning speed termination of parental rights from birth to about, I think the child was 7 or 8 months old and mother's rights were terminated.
Fair to say there's no challenge to the findings?
Well, the findings are based on one-sided report, right, which is that of the DCF, and whatever DCF said my client said. My client was not afforded the opportunity to be present at trial.
I understand, but in your brief I didn't read any specific challenges to the findings.
Yes, there's one, which would be that Mother had the money to appear in court, which she did not, and which is made clear by the 21A reports submitted by DCF and by her attorney's representation to the court.
It seemed to me at the date of the first trial, and I may have my dates confused, but the month before the second trial.
February 27th, yes, Your Honor.
Counsel made a representation that Mom had received her stipend today, and so therefore didn't have time to purchase a bus ticket. And so we're really seeking a continuance for 30 days so that she can be present, because it seemed like the request for a virtual appearance wasn't going her way.
I would disagree with the characterization of her counsel's representation to the court. What happened was her counsel on February 21st filed a motion for virtual appearance, making on the grounds that Mother could not afford to come back and had no place to stay. That was denied the same day, out of hand, administratively without argument by the judge. Her counsel renewed that request at the day of trial, but he knew that it had already been denied and it would be denied, and so as like a Hail Mary, okay, she's going to get her disability check today, can we push it off? And the court said, all right, February 27th. And then her attorney said, well, that's the day she gets her disability payment. So let's do it February 30th, or March 30th. So they kicked it out then. But there's no representation that my client could afford a bus ticket back by taking from the disability that she was using to live. It was all right, we're not going to get the virtual appearance, which was denied out of hand without good reason,
The judge had the view that the mother had removed herself voluntarily to West Virginia, and that was the reason that was her obligation to come back. I'm sorry to interrupt your answer.
Not at all, Your Honor. I mean, if we take trial judge at her word.
So credibility was the issue. I like to assess credibility when they're here in person in part also, as well as.
So the court is not, to quote the judge, the court is not going to allow virtual participation for a parent. Just the assessment of credibility I've found is very difficult to do by Zoom, and it is so important in a termination case that I'm just not comfortable doing that. That's a hard and fast rule, denying opportunity for a parent, right? And if we take her at her words, it appears as though she's treating parents different than the Department of Children's witnesses, which, whether or not that's strict scrutiny or rational basis differential treatment, it doesn't satisfy rational basis to assume that a parent is less credible than the department's witness and less worthy of appearing, as was determined in Patty, comports with due process. And it bears in mind here that the standing orders of the SJC and the standing orders of the juvenile court, presuming in-person hearings for terminations, are all intended to preserve the constitutional due process rights of a parent, of the subject of the proceedings.
Aren't they
right?
also intended to assist the judge in making fact-finding decisions? I mean, adoption of Patty says, quoting Vasquez-Diaz, although generally not preferable, with today's video conferencing technology, a virtual hearing can approximate a live hearing. Couldn't the judge in her discretion under the standing order say, in these circumstances, I need to see the witnesses to decide credibility?
I think if the judge had analyzed and said, in these circumstances, right, mother, I don't know, in the past had people in the room when she appeared, or had problems by video, but she didn't do that.
What about mother not showing up for the final pretrial by video?
Well, she didn't say that, right? It was part of the reason, right? And I mean, that's not what the trial judge said. She said, I'm not.
Mom up and left, knowing that there was a trial imminent.
Right.
And I have concerns about whether I'm not, given that permanency means permanent, I have concerns about whether or not I can assess the credibility of the parent on the virtual showing as well as I could in person. And I don't know that that speaks directly to the DCF witnesses or not. I mean, it may be that she wanted to hear from the social workers in person as well. I don't know.
But what does her leaving the state have to do with her ability to assess mother's credibility on Zoom? I don't think it does, and I think it's punitive. I think the judge is saying, yeah, I'm upset that mom left, right?
That's speculative, isn't it? Where do you get that from?
Well, by her words, especially for a parent who started the case here and only recently, up and left. The judge is clearly perturbed by the fact that this parent left, right? And she made clear in the record that it's not abandonment, but it's going down that path, right? But that has, the finding of unfitness has no part in the due process equation, right?
Didn't she also say if mom was here and she was in compliance for the next 27 days, I don't know whether or not she'd be unfit or not. I mean,
right.
She was kind of speaking openly about here we are and what do we do?
Right. I think the Lonergan-Gillen case is of this court is really clear that where a judge has discretion to apply a hard and fast rule of not allowing virtual participation is an abuse of discretion. And it's not in any of the briefs, but this court also ruled in a divorce case where a parent was out of the country and couldn't make it back, that it was an abuse of discretion to deny her to appear virtually. This was pre-COVID, because at the heart of the decision to deny her appearing virtually was not the child's best interest. The judge had made, it had, the penultimate interest in these cases is the child's best interest. Like, why not allow a virtual appearance, especially where here the record is clear that the mom wanted to sign an open adoption agreement, right? And she, why not have mom testify and have visitation. Instead, you terminate rights, deny all visitation. It just, you know, it doesn't make sense. It's a structural error, right? Denying a parent the opportunity to appear. And the courts, I mean, this is Brockton Court, which is constructed in, I think, 99. I mean, it's pretty state-of-the-art for courts in Massachusetts. The courts subsisted, and Patty shows that, like, Zoom trials can comport with due process, and it's okay if, you know, the state goes forward via Zoom, and lots of people's rights were terminated via Zoom, right? And so why not, when a parent asks to be able to appear and rebut the allegations against her, then it's not okay.
Why is it that the, sorry, go ahead. No, go ahead.
Would it have been okay if mom denied it, if the court denied it because mom was simply asking for it as a matter of convenience? She didn't feel like coming back to testify at trial in person.
Yes, Your Honor.
That would have been okay?
I think that would have been okay, Your Honor.
So how do we know that didn't happen here?
I'm sorry, if mom just said she wanted to appear out of convenience, is that?
Well, she didn't say out of convenience. I mean, but she didn't submit any affidavit that said she didn't have the funds, did she? Was there an affidavit submitted?
No, there was no affidavit submitted, but there need not be an affidavit submitted, Your Honor. I mean, that's neither here nor there, right? An affidavit is not evidence, right? It's clearly hearsay.
What if the court just didn't believe that mom didn't have the funds to appear, and she just didn't appear because she didn't want to travel back from West Virginia?
But that's not what happened, Your Honor. The court took, unless she doesn't believe Attorney Clerkin, who's a very well-respected trial attorney in Brockton and Norfolk County, his representations, who I know very well and have had many cases with him, unless she didn't believe him, like, she stamped the day the motion was filed, denied. It was filed February 21st, denied. That's the first exhibit in my addendum.
She didn't draw the adverse inference from mother's failure to appear until after DCF had presented the testimony of the ongoing worker and the adoption worker.
Correct. She drew the adverse interest at trial, Your Honor.
And so during that testimony, Judge Gershenkorn heard evidence about the mother's statements to the ongoing worker about her move to West Virginia and whether she was going to come back and all of that. So the judge could consider that in drawing the adverse inference.
Okay. So, yes, which mother was not afforded the opportunity to rebut with her own words, right? This is the DCF stating what mother said. Mother wasn't there because the motion was denied. She has certainly, under Baxter, Lefkowitz, the Supreme Court cases, that a presumption or an adverse inference regarding facts may be drawn by a refusal to testify. And in Talek, that was extended to when a mother inexplicably did not appear at a termination trial and didn't reopen the evidence nor explained on appeal why she didn't appear. Under those circumstances, it is reasonable to draw adverse inferences as to the facts presented by DCF. But under Lefkowitz and Baxter and the Scottish cases, and there's a Seventh Circuit case that lays it out really well, a judge cannot draw an adverse inference of civil liability based on a parent's invocation of Fifth Amendment rights. It is patently unreasonable to know that a mother is out of state.
Was the mother being prosecuted? Was there a criminal case pending?
No,
when
Your
did
Honor.
she invoke her Fifth Amendment rights?
No, Your Honor. No, Your Honor. This is Talek extending that Fifth Amendment kind of case law of Baxter and Lefkowitz to when a parent doesn't show up and saying, in this case, when, and Talek stated that when a mother no-shows at the termination trial, right, and she gives no explanation, and she doesn't reopen the evidence, and I can quote that case.
But in this case, the explanation that she gave, that
Right,
Attorney
Your Honor.
Clerkin gave on her behalf, it was, she doesn't have the bus fare now.
Correct, Your Honor.
She'll get her Social Security check on February 27th and again on March 27th. So if you continue the case to March 30th, she will have the bus fare. And my client has told me she'll have the bus fare. Why, and then the mother doesn't show up, and you're saying we need to credit the mother's non-existent testimony that she didn't have the bus fare?
No, it's in the record, Your Honor. It's in the record in the 21A report submitted to the court before the first date of trial on February 23rd. I'm sorry. Pages 195 to 196, that mom didn't have the money before that.
On February 23rd.
On February 23rd was the date of the court update. And then at trial in March, the 21A letter, the court update letter, which DCF has to submit at each court hearing, on page 202, the evidence in the record, which is after the denial of the motion, but anyways, it's in the record. Mom does not, the social worker submitted a court update, which was put into evidence, saying there was a mix-up at Social Security. Mom still did not get her disability checks and cannot afford to be here today. So the record is quite clear that mother did not have the money to appear.
That was the first day?
That was both the first and the second day, Your Honor.
And could mom have sought some type of funding to provide for her to have travel?
That's not in the record, Your Honor. It's not in the record, Your Honor. Could she have borrowed money?
Said at some point that mother did not seek funds for transportation.
I believe it is in my sister's and in DCF's papers that she could have filed a motion for funds for extra costs. Maybe. I don't know. That may be a procedural route that she could have taken. I don't think that should impact whether or not she was able to appear virtually. I mean, it's a small ask, Your Honor, in light of the due process implications on the other side. And I see my time is up, Your Honors.
Very well argued, Attorney.
Thank you, Your Honors.
We will now hear from Attorney Gallup. Representing the department.
All right. Good morning, Julie Gallup on behalf of the Department of Children and Families. The department is asking for this court to affirm the judgment and decree of the lower court terminating mother's parental rights. The issue of the denial of the motion for virtual participation was not preserved when counsel asked for the mother to be able to appear virtually and then asked for a continuance. The judge allowed the continuance. Trial started on March 30th, and he neither moved for another continuance nor requested her ability to participate virtually.
So, I mean, counsel was kind of in a tough spot, right? I mean, the motion to appear virtually was denied. So what is he to do if mom's not here? I mean, you almost have to ask for a continuance, right? I mean.
And he did, and he, in the February court date, he did ask for that continuance, but on the March court date, he neither asked for a continuance nor, renewed his motion for virtual participation. And so that's the issue that, that this was waived. The whole point is that you need to, bring the objection or bring the issue to the court's attention so that the court can make a correction if it's necessary. And the issue of, with regard to whether mother had the funds or did not have the funds, the attorney made representations to the court but did not have any, signed affidavit from mother explaining what the situation was. Now, due process.
Well, they explained the situation was that she didn't have funds to take the bus back from West Virginia. And even if she did, she had no place to stay if she came back from West Virginia. So mom's asking to appear virtually, which seems like a reasonable request, no?
Well, it is a reasonable request, but in this circumstance, the judge made clear that it was difficult for her to assess credibility through Zoom. And, the standing order identifies that the judge has the discretion to grant a hybrid proceeding where, some people are virtual and some people are in person, depending upon what the resources of the court are and the circumstances of that individual case are. And the judge explained that credibility, given the significance and the importance of these proceedings, parental rights are at stake. Having, live testimony from a person where you can, see their body language more clearly and also eye contact was important to the judge in this circumstance.
I get it, but, even though Zoom may not be optimal, and we've pivoted to Zoom for so many things, even though we may not think it's optimal, wouldn't have been our first choice, isn't that better than not having to testify at all?
So in these cases, due process requires that a parent has the opportunity to rebut allegations of, adverse allegations of parental child rearing capabilities. And Mother had that. Mother was represented by counsel. She had notice. And she did have the opportunity to be heard. She didn't show up. Now, this reminds of adoption of Edmund in that case where it was an incarcerated parent who was, prevented from coming to court. There's a, a conversation, or not, there's dicta in there which discusses the options that trial counsel for that parent could have taken to rebut those adverse allegations of his parental capacity, which included something such as like even filing an affidavit from the father. So, Mother was represented by counsel. He didn't call any witnesses, and he didn't submit any exhibits. He had an opportunity to cross-examine the department's witnesses, and he did that. So now with regard to the issue of, the finding of Mother's unfitness.
Let me ask you, before we get to that.
Sure.
Just so I'm clear. Let's just assume for the sake of discussion that Mom legitimately did not have the money or the means to come back and be heard. Too bad, so sad?
So, I mean, the record of this case is that on multiple occasions, Mother had reliable income on a monthly basis from Social Security and found herself in situations with people who then took her money or took her benefits cards, so she did not have an ability to then pay for things that she needed. The judge made a finding that she moved to West Virginia to live with an individual who had actually already previously taken Mother's money and assistance benefits.
So that gets to your Attorney Newble's position that it seems punitive. The judge was annoyed by that.
Well, I would say that's speculation. I don't know what the judge's feelings were. From the record, she makes a statement that...
So let's get back to my hypothetical, which doesn't include all those extraneous factors that you just talked about. Let's assume for the sake of discussion that Mom legitimately does not have the money to return from West Virginia to be heard. Too bad, so sad.
She knew well in advance of her decision to move to West Virginia when the case was scheduled for trial. She was in court in November when the judge made the trial date for February. The docket reflects Mom present. And then after that court date, the judge emailed a status and scheduling order to all counsel, which includes in there the pretrial date and the trial dates. That order also specifies the pretrial will be by Zoom. It doesn't explicitly say trial in person, but it does say all parties shall appear. So, I mean, I would say taken together, the fact that there is that carve-out with regard to the pretrial that would, in reasonable inferences, we need to be there in person. So Mother had the opportunity, Mother had months of notice for when she needed to be in Brockton. And she took no steps to ensure that she could even appear virtually before moving. She could have filed a motion anytime between November and the end of February asking for this relief. Now, we know that she left, I think, sometime near the end of January. She also had, opportunity just to make sure, before I make this decision, this is an important case, I should be there for, is this going to work? And so this is, again, part of the, questionable decision-making that the judge identified in finding mother unfit to care for this child. That there were moments where she appeared to make a decision that was, a significant decision. I want to give my child to my boyfriend's mother. Then 15 minutes later, never mind. I've decided that wasn't a good idea. So,
is it fair to infer that mom had the funds to get to West Virginia and had the funds to establish some type of housing in West Virginia?
It's not. I would say that the record is unclear about that. We assume that she made it to West Virginia. She represented to the department. She was in West Virginia. She texted the social worker that she'd obtained housing, but she didn't provide a landlord, like a telephone number to confirm, nor like a copy of a lease saying, like, I actually have obtained housing. So, in the absence of additional information, I would say that, we can't actually say what happened with these funds or what happened with the money, but what the judge was working with were these patterns of, questionable decision-making, which contributed to the finding of unfitness.
At the end of the day, it's an abuse of discretion, correct?
It is an abuse of discretion. Under the standing order, whether to allow a hybrid hearing, it's the judge's discretion, as long as the judge considers, the resources of the court, the circumstances of the case, which the judge explained. And, basically, mom knew well in advance of her decision to leave the state. When this case was scheduled for trial, she could have even just filed the motion before she got on the bus, saying, like, just make sure. And so from there, again, I would say that the denial of the motion for virtual participation was not preserved, but, if this court wishes, obviously, that the judge did not abuse her discretion. She made it plain, given the rights at stake in these cases, and her decision that credibility was difficult over Zoom to assess. And, credibility is so significant in terms of, for this judge to make the findings. So I would say that there was no abuse of discretion nor error, and I would ask for this court to affirm the lower court's decree.
Attorney Gallup, thank you very much. Attorney O'Brien.
May it please the court. Good morning, Your Honors. Gary O'Brien on behalf of the minor child appellee. Just following up on a couple of points that were raised earlier by Your Honors. One thing with regard to the in-person component is that both DCF social workers did testify in person. I don't think the judge was making any clarifications about parents wanting definitely to be in person, but other witnesses could be virtual. Secondly, I think, as Your Honor just pointed out, with regard to the issue of the court's discretion, I think we start with the juvenile court rule, which say all trials shall be in person. And from that aspect, then it's kind of looking at what is the court's discretion. I think from Your Honor's hypothetical about there was a lot of ambiguity about the mother's finances, perhaps. Perhaps it wasn't stated in the record of what actually the situation was. But I think it's also important for this court to keep in mind that my client's older sister had gone through in front of this same judge. All of those are referenced in the findings, the whole history of mom with the older child who she had agreed to a termination of parental rights just in November of the year. And then 2 or 3 months later, she decides she's going to West Virginia, knowing that this trial is coming up. I think all of that combines to kind of put in mind the trial courts, starting with the rule that all trials shall be in person, and then what the discretion that the trial court is looking at, also keeping in mind, looking at adoption of Hugh and all the cases, that there are two parts to this equation as well, that there's the child and the need for permanency and the need of the constitutional rights with regard to that, versus mother's due process rights to be notified and be appointed counsel, which she had, and an opportunity to be heard. It doesn't necessarily say what she does with that opportunity in terms of the trial. So I think those were the main points that we wanted to address. Other that's in our brief. I think with regard to the issues that counsel had brought up with regard to some of the record that mom was saying she didn't have funds, that's what mom was reporting to the social worker. I think the social worker testified to the court, and then the court was able to make an adverse inference once she had heard that as well. So I think for all the reasons I think that the panel's already heard from counsel and kind of gone through, we would just be supportive of the fact that this case should be affirmed on appeal for all the reasons stated in the brief and for what's been stated at argument. I believe just in terms of my client, that just to point out in the record that the adoption plan at trial submitted was for her to be with her sister, whose mother had already agreed to a termination of parental rights with regard to her sister. The plan was for the two of them to be together, and I think the court was mindful of all of that. So I see if there's no questions for me that I would rest the rest on my brief. So.
Attorney O'Brien, thank you kindly.
Thank you, Your Honor.
Our final matter for the day is 22P1170, John Doe, number 464933. That's the Sex Offender Registry Board. Attorney Gauthier.
Good morning, Your Honors. May it please the Court. My name is Edward Gauthier, and I'm appearing today to argue on behalf of the plaintiff appellant John Doe. This is an appeal of a final Level 3 classification of the Sex Offender Registry Board. Our brief raises a single issue that this Court has seen many times, and that is the misapplication of Factor 2, repetitive and compulsive behavior. But before I get to the meat of the argument, I'd like to quickly address the elephant in the room, and that is that this final classification was January 13, 2021, and as a result, 3 years have passed since the final classification.
So you're eligible for another hearing?
I did receive a phone call from board counsel asking me if my client would like a de novo petitioner-initiated reclassification. Unfortunately, you can't simultaneously have a pending appeal and have a final classification, and unfortunately, again, I do not have consent from my client to dismiss this appeal. So regardless, I can say that regardless of how this court decides this appeal, my client will be entitled to a de novo classification, either when the appeal is denied or granted. I would say that the only meat of this appeal then is if we were to be victorious, my client would be removed from the internet and the board would not be able to disseminate his biographical information pending his new hearing. So that's essentially the difference.
Pending what?
A new hearing. So he gets a new hearing regardless. But if we were to win on appeal and this court were to remand the case for a new hearing, for the period of time between remand and the new hearing, he would be unclassified and thus would be removed from the internet and he wouldn't have his information disseminated. So the Factor 2 issue, which this court has seen a number of times.
And it's undisputed that it was misapplied, right?
It was misapplied.
I think everybody agrees. The department says that notwithstanding, if you even take out Factor 2, there was still ample evidence for the board to determine he still should be a registered level, classified as level 3.
That is the board's position, yes. Our position
You
is
say
the
that.
opposite. So the issue isn't whether the evidence was sufficient. It's not a Lattimore or a substantial evidence query. From the case law 22188, the issue is, in the past, this court and the SJC have recognized that the board is imbued with the technical expertise and the competence to make final agency decisions on the risk of reoffense and degree of danger of sex offenders, and that this court should defer to their expertise. In that vein, in 22188, this court essentially said that if there's a chance that this erroneous application of a high risk, in this case, this isn't the application of a risk elevating factor that the board on its own developed. This is a statutory high risk factor. So there's an assumption that if the board hearing examiner finds this particular factor, there is a statutory presumption that this is a high risk factor. And in the past, this court, in its deference to the board, has given them the power with their expertise to make these decisions. Our position on cases like this with the misapplication of factor 2 and supported by the case law is that if there's any chance that this decision may have been different, then it should be remanded to the board for a rehearing without the consideration of factor 2. In terms of actual...
Is that the standard?
The standard from 2218 says if it's to ask whether the error may have affected the classification, and if so, to remand to the board. This best comports with our statutory mandate to determine whether the substantial rights of any party may have been prejudiced.
So we have to be satisfied that it may have.
May have. And in terms of facts of this case, the facts of this case, like most of these cases, is fairly straightforward and simple. There were risk elevating and risk mitigating factors. Our position is what weighs in our client's favor in terms of why his substantial rights may have been affected is, aside from his sexual offending, Doe has no other criminal record. He's a 31-year-old man, and he has no record other than this from 2010 to 2012. And of course, the board emphasizes that there are 4 victims. There's one actual victim of a contact sex offense, the little boy. The others were present in the home and were victims by proxy of his primary sexual offending. He only had 3D reports during 8 years of prison. He did take responsibility. He took a plea to a wide variety of charges of contact and non-contact sex offenses. And one of the factors that the board considers is the range of potential victims. The scariest sex offender to the public for whom the public dissemination is most warranted is the sex offender who randomly attacks a stranger in a parking lot.
Sure. Because here we have somebody who was in a position of authority, who was in the house. It was boys and girls, didn't really take, as I understand it, full advantage of the treatment that was offered to him while he was serving a sentence. And so there were a number of factors that I didn't really see you challenge in your brief, really other than the weight of some of the mitigators. And
actually, Your Honor, we will concede that we do not challenge the specific weight or finding of any of the risk mitigating or elevating factors. Each of the factors, I'm not going to go through each of them, they're in the brief, are in the record and they're supported by the record. And the
same is true for the single remaining high risk factor?
The adult children, or the adult perpetrator with the child victim is supported by the record. We don't contest the factual findings and the factors nor the weight given to the factors. Ours is simply an argument that if you excise factor 2, what you're left with is the possibility that this may have gone a different way, and if that's the case, case law requires a remand. If there are no further questions, Doe would rest on his brief.
thank you kindly, Attorney Garfield.
Thank you.
Good afternoon. If it pleases the court, David Chennai for the board. This is a pretty straightforward case. I mean, again, it's one issue. The board's position is even if you take factor 2 out of the equation, the evidence speaks for itself at the level 2. I mean, the level 3 classification is really dictated by the evidence. I think 22188 actually has a step before the possibility that it may have impacted the decision, and that step is, first you decide, was it misapplied, a factor misapplied. Of course, we agree factor 2 was misapplied. It was written, this decision was written before the Wilkins decision came out, and changing the scope of factor 2. And the second part is, if a factor is misapplied, the next step is to query whether or not the remaining factors and facts dictate the classification level. It's only if the answer is no to that, then you decide whether or not the application of the factor may have possibly affected the decision. Our position is we don't get past the second step because of the facts of this case. That's essentially the board's position. I've briefed it fairly well in my brief. I'm hoping this is the last time I ever have to do a factor 2 case. I think they're running out of them, but the board would rest on the brief unless there's specific questions.
Attorney Shania, I appreciate your courtesy. I don't see any specific questions. The matter stands submitted. And that concludes our business for the morning, for the day.
Thank you.
Thank you. Court stands in recess.